Well, hey everybody, I'm back with another little video lecture, and this one is about arrests. It's for Module 5 and Forum 5. Just going to give you a little heads up on this if you want to hang in here, because there's a couple of extra credit assignments that are buried in here, and we'll get to them a little bit later, but I want to give you a couple prefatory comments about arrests. I found a lot of times that there is a continuing misunderstanding between police and lawyers in the area of arrests. And generally speaking, the definition of an arrest is any time that a person's locomotion has been interrupted. So in other words, if someone asks a police officer on the witness stand, well, if Mr. Jones had wanted to leave, would you have let him leave? And the police officer says, well, no, I wouldn't have let him leave. Well, then, you know, effectively the man was under arrest. I mean, that didn't even mean that his hands had to be shackled or cuffed, or, you know, he didn't have to be taken downtown or any of those things, you know. So a lot of times this is kind of a confusing area. One of the areas that I have the most problem with is in the area where under the law it says that police are supposed to take people for a breathalyzer test, you know, and then they claim that they're not under arrest when they're being taken downtown for a breathalyzer test. Well, they're not voluntarily necessarily going down there to take a breathalyzer test. I mean, even though they may it's still kind of under duress. They may say to him, well, I'm going to need to take you downtown. The other thing is this whole issue in DUIs with taking blood tests. And I'll tell you, quite frankly, there's a new trend in this area right here. And it's starting right out. I did talk with you a little bit about this. And in that instance, it's this idea that they can get a warrant over the phone to take a person to a hospital for a blood draw, where they in turn will check their blood and determine if they're driving under the influence. Now, one of the things on that that's bad is that the law requires that any kind of blood test be taken from whole blood, and unfortunately some hospitals use a different technique, which is from platelets of blood. So in other words, they strip off the liquid and they're basically testing platelets, so in other words red blood cells. So that's not the whole blood, I mean, is the problem. So sometimes I've had cases where there's a significant difference, especially on these lower registers of people's test results. So someone have like a 10 or 11 could actually be like a 7 or an 8, or someone has an 8 that could actually be a 5 or a 6. So it's a real problem area, and a lot of times ignored even by good defense attorneys. They totally forget this or space it out, but the law clearly says whole blood, and so this is another area where someone could be accused of DUI when in fact they are maybe at a 5 or 6 instead of an 8. So something to think about. This whole thing of, you know, when are you under arrest, it's a kind of a confusing area even for police and lawyers, and a constant thing. It's always up for grabs. Well, one of the things to know that arrests are a vital tool, you know, in other words, the police do need to take people into arrest at times, and this is covered by the Fourth Amendment under seizure of person. It is obviously more invasive than just to stop and question someone on the street, kind of like what we call a Terry stop, but it's less invasive, obviously, than being in prison. So you don't take somebody right off the street and put them in prison. In other words, they're eligible to be bonded out, and they're eligible for certain other things in most cases. Well, it's also important that we satisfy two elements when we are working on a Fourth Amendment reasonable test on lawful arrests, and one of them is must be based on probable cause. I mean, you hear that word a lot. Remember that in the Terry stop, it was just reasonable cause to believe that a crime may have been committed, whereas in the standard used for an actual arrest, that's a more invasive procedure. They can actually go in your pockets and things like that. in a true arrest, then there is a requirement of full probable cause, which is a basic belief or probable cause to believe that a crime has been committed. And also the manner of the arrest has to be reasonable. So in other words, it's not abusive, it's not like a Rodney King, or later on we'll talk about this Tennessee versus Garner, which is a very, very bad situation. Also important to remember that, in other words, in balancing this, we're talking about, once again, stopping locomotion. So it's not required that it be total confinement per se, like being locked in the back seat in handcuffs, but just being grabbed by the arm by a police officer is sufficient to be considered an arrest. Totality of circumstances, always have to look at that. In other words, what all was going on at the time? Was it unclear? And so sometimes it can be a little confusing on both sides of whether or not the person was under arrest or if he thought he was under arrest. Here's an extra credit thing I've already mentioned to you that I'd like you to do, and that is find a local website for your own police department. And this is really good if you live in other states other than in Indiana, or even if you live in other cities around Indiana. So see if you can find guidelines for officers in executing an arrest. Sometimes they have that standard. They have a standard for use of force. And so these are good things for us to share. We could share in the discussion board. Or if you just want to send it to me as a separate attachment to an email, I'll give you full credit for that over and above your regular discussion board. Always important to look at these different guidelines, see if there's any kind of variance on your website. Always should say something about probable cause. It also ought to say something about what probable cause is, that it's more than reasonable suspicion, but it's not as much as proof beyond a reasonable doubt. It's also, police officers, have to make decisions, and so it's a question of what facts are as they see them. And generally police are going to be accepted by the courts in terms of their interpretation of what's going on at the time. This can use hearsay at this point. This is a pretrial aspect of it, so it is possible that some parts of this can be hearsay. It can also be direct evidence, such as witness testimony by the police officer. It can be hearsay from victims in terms of from reports, other police officer, informant, like a confidential informant, someone like that. Cannot be used in the trial, but it can be used at the probable cause stage to get permission to arrest the person. You can arrest the person and then go in and ask for a warrant or to bring charges, affidavit to bring the charges against them, and that's where you can actually resort to hearsay to bring the charges. So again, probable cause depends on totality of circumstances. So everything that's around it, everything that's available to consider. Also know that most of the time, if someone is in their home, there has to be an arrest warrant. So you can't just go in somebody's house. Now there are emergency exceptions. House is on fire. Someone tells a police officer that he saw someone carry a screaming child into the house that was trying to kick and fight and so forth. So they might want to investigate to see if that was a kidnapping, for example. That might be borderline there. What if they're taking their own child in for a spanking or something? Yes, it's true. Spanking is still legal. Tennessee versus Garner. This is your second extra credit assignment. Do one or the other. Don't do both. But if you want to do your own side assignment here, you could look into Tennessee versus Garner and give us your interpretation of what happened there. This is more of a short paper type summary thing, just a page or so on what you think about Tennessee versus Garner. I think we're probably going to have you brief that anyway at some point, but I'm just saying if you want to go deeper on Tennessee versus Garner, the case citation 471 U.S. 1985. It's a case about a teenager, 15 years old, was shot to death by a police officer. Garner's actually the child's father, sued on behalf of the child who was deceased, struck in the back by a hollow tip bullet, which is a man killer type bullet. And the whole purpose of it was the kid was trying to climb over a fence. Police officer shot him. Now he clearly, the police officer said, his name was Hyman, and he admitted that he didn't see a gun, he didn't think there was a gun, he figured he was unarmed, is his exact statement in his testimony. Yet he still shot the kid in the back. Fleeing felon rule changed based on this case, the Garner case. Very important case. You cannot shoot a fleeing felon as long as if they're coming at you and they're armed, you can shoot them. If they tend to show something that appears to be a weapon, you can still even shoot them, even shoot to wound if possible. But you cannot shoot a person in the back when they have no weapon. And so the father in this case, like I said, he filed a lawsuit, tried to seek damages. District court in federal court actually entered a summary judgment or judgment against the plaintiff and for the defendant, which would be the police officer, and I believe it was Memphis, the city of Memphis. And so basically what he's saying is that there was an assumption of the risk at the trial level that the child should not get the benefit in this case of violation of his civil rights because he was engaged in some kind of misconduct by trespassing on this property. However, the Court of Appeals reversed this decision and held that the killing of a fleeing suspect is a seizure, in other words, an arrest. It's a form of arrest. In other words, you shoot the person, you have interrupted their locomotion in a big way. And so if there was no evidence of posing a safety threat to the police officer, then you cannot shoot any kind of a fleeing felon. So in other words, if they're not shooting at you, if they're not pointing a weapon at you, if they're not even pointing something that you think might be a weapon at you, you cannot engage in any kind of deadly force. And that's a new change in the law as of this decision, 1985. Very important, 6-3 decision. Judge White wrote for the majority that the Fourth Amendment prohibits use of deadly force unless it is necessary to prevent the escaping felon and the officer sees this as a significant threat of violence on the officer or the community. The officer in this case admitted there didn't seem to be any threat there. There was no weapon. Said he was unarmed, figured he was unarmed, so the court said in those situations, without more, then you're not allowed to shoot a suspect as a kind of ultimate form of arrest. So look that over. Like I said, we're going to have you brief that. But also, if you want to go deeper on that and dig into it and say, do you agree or disagree with the outcome, let us know. Well, hey, that's basically it for Module 5. We wanted to let you know that we'll be doing more and more of these. There'll be at least 16 of them for you to look at. So stay in touch, stay tuned, and we'll come back with some more. Thank you.